for attending. We appreciate it. Today, we're going to work through some of the recent developments in asset protection in really every sector: titling, entities, trusts, and exempt assets. And with that, we'll go into the agenda. We'll work through a general introduction of what asset protection is, how the protective entities come into play. We'll first start in terms of entities with LLCs and how the choice of jurisdiction is instrumental, and when and how you can ensure enforcement of whatever entity you choose. Why certain laws are chosen, when they're enforceable, when they're not enforceable. We'll get into the issue of the single member LLC. We'll go through the cases and how to avoid single member status and the weaknesses associated with being a solo LLC. We'll talk about offshore LLCs, and then we'll go through the keys to making an LLC structure work, and then we'll go through domestic and foreign asset protection trusts. It's a lot to work through, so we'll hit certain points. If you have a question, please ask the question or enter the question into the system, and we will get to it. With that, we'll go into the introduction. What is asset protection? A lot of people, you can't take asset protection as a class in law school. It's an amalgamation of different areas of law. That's why there's so few of us practicing actually sophisticated, exotic asset protection work. It involves a number of areas, including corporate, tax, international law, trust law, in terms of structuring what you have, not in hiding what you have, but structuring what you have. So in the case of you falling into litigation, you can be confident that you retain at least what's protected in a structure. It's not hiding, you see on the slide, it's not hiding assets, it's not evading taxes, it's just not really absconding. It's creating, before problems arise on a sunny day, a structure that's going to stand up to later litigation. The basics are pretty straightforward, it seems, but each basic area of asset protection: titling, the four areas of titling, exemption, trusts, and entities. For instance, titling varies from state to state. In Florida, we have statutes allowing for husband and wife, for instance, to title either personal property, non-real estate, and real estate in husband and wife's name, tenancy by the entirety. Mostly states in the Midwest and West don't allow for tenancy by the entirety. So what that means is, in those states, we don't have that tool in the tool chest. That's a titling issue. For instance, if we open up an account, a bank account in Florida, we can title the account by the entireties. What that means is, if mom is sued alone, the suit will not allow for collection of that bank account because it's titled by the entireties in husband and wife. It's as if they both own it as one person. Where that's not allowed in the most Midwestern states, California, you can sue one spouse or the other, husband or wife, and reach at least half the account. So that's a titling issue. There are other issues that allow for protections in titling. Exemptions is the second area of asset protection. Certain assets in certain states, usually depending on residency in that state. So if you're a resident of Florida, for instance, and you purchase a homestead or life insurance, it's an exempt asset. It doesn't have to be titled in any particular way. The life insurance, for instance, in Florida, you have to be the owner and insured of the policy, whereas in some states you could be the owner and not the insured and it be exempt. So you have to look at the exemption rules, but the exemptions, if followed and you own that property, are completely protected. In Florida, we have the homestead. If you have a homestead, you own the property in your own name. You can even be subject to a judgment, and the homestead is not available to a creditor. It's an interesting exception to the exceptions. So you have an exempt asset, but you usually have to purchase that before you have any trouble. Not true of the homestead in Florida. You can buy that running away from a creditor. It's just an example of an exempt asset that's kind of bulletproof. Trusts are 500 years old, basically. The English law allowed for husband to go away to war, putting assets in trust for wife and children, or just for the eldest son, etc. You would pick a different trustee. So it would be dad would put money in trust for son, and the trustee would have the legal right to manage the asset, and the son, for instance, or daughter, whatever, the beneficiary would have the beneficial ownership of the asset. So if the trustee allowed a distribution or use of trust assets, then the beneficiary could utilize the assets. If the trustee does not allow for it, then the beneficiary may not. This created a division of title. It's really its own seminar, but as one of the arrows in the quiver, trusts divide legal title to the trustee and beneficial title to the beneficiary. So if the beneficiary gets into trouble, gets sued, and loses a judgment or doesn't pay a debt, the creditor has no ability to get into the trust because the trustee can say, well, I'm not going to make a distribution. It's a fascinating, well-trodden, hundreds of years old protective device that is still very, very protective. A lot of times we've got clients who create trusts or come in with trusts that they want to revise, where they've created a mandatory distribution to a beneficiary. It's very common. You create a trust, and I want to create a trust for my kids. I have more than I need. And when they're 30, they get $1 million. When they're 34, they get $2 million, whatever. When they're 50, they get the rest of the corpus of the trust. The problem with that is that if you place a distribution time in the trust, a moment where the beneficiary has the right, it's not up to the trustee, the beneficiary has the right to reach those assets become completely exposed. It's a little developed idea for whatever reason among lawyers, but you have to be very careful with that. When we have to create a mandatory distribution at that moment, any creditor of that beneficiary can take those assets, even if they're not distributed. It's good to know that. Then we deal with entities, which has come to be LLCs. So LLCs, because of their dynamic and flexible nature, we use with trusts, we use with titling, we use with exemptions to round out asset protection plans. We'll get into LLCs in depth, but as an example, an LLC is not as protective as a trust. So we may have a trust that's more protective that owns an LLC. So if the beneficiary of the trust is sued, no way to reach inside to even touch the LLC. Similarly, we may, if we have an LLC and we want to develop protections that are greater than the LLC statute allows, we can title the LLC in the husband and wife tenancy by the entirety. We develop a lot of these combinations to get the most out of the whole plan. We have on the slides the similarities and distinctions of trusts, and for instance, LLCs. The trusts divide the title, LLCs don't. So you're not going to get the divided protection of title in LLCs. We'll get to exactly what the LLCs offer. It's limited. It's a limitation on what is available to a creditor of an owner of an LLC. It's not a divided title. when we get to entities, we're now talking about the evolution, because it's very hard to understand exactly how these entities work without a little background. So we have corporations. Many people say, well, how are you getting into asset protection? Isn't this a new idea? Not really, not really. I was a corporate lawyer for the first 10 years of my practice, and I was doing a lot of asset protection, didn't even really know it in some ways. Corporations, what they do is they insulate the owners from liability. So if you have a corporate manufacturer and something goes wrong with the widget, or someone falls in the facility, the shareholder is not liable. It insulates the owners from the liabilities associated with the business, unless there's fraud or there's some kind of alter ego. You're using the corporation to pay your home electric bill, that kind of silliness. In general, it does not create any kind of liability for the owners. It shields the owners from obligations of the business. Then that's called inside asset protection. The LLC does the same kind of thing. Let's see if it's the next slide. Yeah, so we move into the idea of inside asset protection, which what happens inside the business is not a liability of the owners, to outside asset protection, which is, okay, I own shares or I own an LLC. If I'm sued individually, is that equity available to the creditor? And the reality is, it depends. It depends on the entity that you use. With a corporation, it's completely available. It's completely available. There is no outside asset protection. For years, we used shareholders agreements and buy-sell agreements, this type of thing. And they are effective in some ways, but like if someone becomes subject to a creditor, their stock's exposed. Does it allow my partner to buy me out if I become exposed? That becomes very cumbersome. Maybe it's a bargain price. There's all kinds of issues that arise. It's better to get into an entity that has this outside asset protection. And basically what that is called the charging lien. So the difference between the corporation essentially and the LLC is that if someone sues a member of an LLC, they don't just take the equity. They can sue for a lien on the equity, which means if a distribution ever takes place, that distribution goes out to the lien holder, judgment holder. So that's the difference. They can't take the equity, but if we make a distribution, the lien goes out to the lien holder at that time. Do you have to make a distribution? No, the lien holder does not hold voting equity or create any leverage with respect to forcing a distribution. That's outside asset protection. It developed through the partnership. So traditionally, you'd have the corporation, you have the partnership. At this point, really no one should be creating a general partnership, which is, the handshake. Let's go into business together. That's a general partnership without filing articles of incorporation. What that does is it makes both general partners, or if there's more than two, liable for anything that happens in the business. You're personally liable for what happens in the business. We still see that from time to time. We have people doing that. It's a complete mistake. So what developed was there was kind of a big brother movement to get rid of the general partnership, which is in general probably a great idea. But what happened is they did it in steps. So you had general partners, which was this, everyone had a say and everyone was liable. And you had limited partnerships where you had a general partner liable for everything. Then you had limited partners, you had these real estate deals, et cetera, where someone would put in money. They had no liability to the operation of the partnership. They could lose their money, but they had no liability to partnership obligations. And then we had a movement of statutory change where we put an L on the front of it. So you had a limited partnership, a limited liability partnership. It's hard to say actually. And then you had a limited liability, limited partnership. And what that did was it took this idea of being a general partner liable for everything to only being not being liable for what happens in the business, like a corporation. So that's a generalization, but they put two L's on the beginning of partnership and they put two L's on the beginning of limited partnership, and all of a sudden the general partners were not liable for the business. That and $5, and you get a very expensive cup of coffee. So we moved into this totally complicated double L or triple LP to the LLC. I mean, everyone started, Wyoming said, let's just do the LLC, because the LLC encapsulates the idea of this inside liability, where you're not liable for what goes on in the business, and also offers the outside asset protection, this limitation to a charging order if you sue an owner known as a member. And that's much more, in many ways, simplified, because you're not altering an existing entity, you're creating this hybrid entity. It took off, and now that's kind of what we use for everything, apart from these certain public offerings, this kind of thing. This slide goes through some of the advantages. It's got the protections. It's very flexible. You don't have annual minutes. You have to be a little careful with LLCs in terms of what's developed over the years, because unlike a corporation, the LLC, because it's open-ended, you create your own rules in many instances. You can create your own rules, and people do, and they mess it up. So it's a little more complicated in terms of really getting it right, but it's a much better entity because of this outside asset protection. This slide enumerates a little more on some of the advantages of the LLC, the relaxed formality, fewer restrictions. It's just a superior vehicle. Also, the tax status. It's a very flexible tax status. If it's a solo LLC, it can be disregarded, or it can be a corporation, either C or S. If it's a multi-member LLC, it's a partnership, an S or a C. A lot of questions come up with husband and wife, especially if you title a tenancy by the entirety. Husband and wife, according to the IRS and their procedure, is only really viewed as a single member in a community property state. Whether that tax status kind of suggests that it loses some of the protections of a multi-member LLC is kind of up in the air. So we've got some additional hurdles. If we think a company's going to become publicly traded, we typically don't use an LLC. It doesn't really correspond all that well to the securities disclosure, the IPO, or the true public exchange structure. And then we'll go through some of the questions here: where to operate, who protects the single member LLC, and some of the doctrines we use for choice of law. Some of this choice of law, we're choosing between which state we should use for the LLC, and then offshore jurisdictions, which we had a part in drafting some of these offshore jurisdictions. You know, which jurisdiction should we use and why? Some of the things as a general point to keep in mind are what basic statute the state followed in creating its LLC. And one of the pieces is this revised Uniform Limited Liability Company Act. Has a lot of weaknesses in it. A lot of the banking lobbies got involved in the institution of some of these acts in the state, and we got to be careful, because although the LLC is so much more protective than the corporation, we want to use the most protective LLC if possible. One thing we look at is when we're choosing our LLC, they all have this charging order protection, but does it stop there? In other words, is the charging order the exclusive remedy? Because what happens is, you know, the judge goes through this litigation, and it could take a year or 2 years, and at the end there's a collection, and the defendant says, well, I've got everything in LLC. You can't have anything. You can go ahead and lien it, but I'm not going to make a distribution. Ha ha ha. And so it becomes kind of an obfuscation of the whole litigation system. And so when we look for which LLC to use, it just depends on the circumstances at the time. But in general, we don't want someone to be able to foreclose, for instance, a charging lien and get to equity. It's a way around this limitation on charging liens. Some states allow it, so we want to avoid those states. You know, in Florida, for instance, we've got the issue of the single member LLC, which we'll go into in a little depth here. And the single member LLC, actually in Florida, I believe it's the only state that explicitly allows it. It generally will be foreclosed unless you can prove that distributions are coming out of that LLC. You can foreclose out your claim on the LLC equity and take the single member equity. So in Florida, we avoid the LLC single member. Like as in some states, you can foreclose. You want to avoid these foreclosure states. The choice depends a lot on this internal affairs doctrine. So I think every state has common law on it. I know Florida has a statute, and I think New York has a statute. Several states have a statute which says if you use an entity in another state, this state will respect the internal affairs of that entity. Of course, we don't know what internal affairs means. That's, you know, what we always end up asking ourselves. My impression is that it's just intended to say, if you use a Delaware LLC, we're going to say, okay, we're not using a Florida nickel, we're using a Delaware nickel. Let's look at the Delaware law when we have to apply the law of the LLC. It's what activity occurred that's applicable to the statute. Which statute do we look at? Well, we've got a Delaware LLC. That's the statute. That's kind of the way the internal affairs doctrine works. Is it always followed? Not really. Not really. It creates a lot of instability because you have these criminals or bad actors who do bad things and utilize these protections, and the court then starts to figure out a way to avoid enforcing those protections through sometimes logical means, sometimes circus-like means. And some of the pieces here we have at the bottom of the slide that we go back to in terms of the choice of law, and then whether the internal affairs doctrine applies, is the statute of limitations on, like, let's say, a fraudulent transfer. So if someone's trying to avoid a creditor and funds a structure, a protective structure, and arguably was running away from the creditor, the statute of the Fraudulent Statute Act, depending on which one we use, which one we go by, will allow for the creditor to go get those assets. You can't avoid me. I'm going to get those assets. But there's a statute of limitations on it. Typically 4 years. After 4 years, you can't go get the assets. You got to go get them within a year when you find out, or within 4 years of the transfer. That's the heavy one in terms of choice of law, but also the charging lien. You know, which charging lien statute do we file? I don't know how we get to it, but if we form a Delaware LLC, how we don't use the charging lien of the Delaware LLC, but courts have avoided it, and we'll go into a little of that. We want to update you on some of these cases. The choice of law, I touched on it. This is the Uniform Voidable Transaction Act. It's this fraudulent. It's the newest iteration of the Fraudulent Transfer Act. It's got some very, very good updates. A lot of the stuff was really retained as it was, but it does have some choice of law issues. For instance, which Fraudulent Transfer Act do we follow? And a lot of it has to do with where's the debtor, where's the home office of the debtor if it's an entity. And then the cases are fascinating. This Wells Fargo versus Barber is a case of a kind of a bad actor where we figure out how far courts will go to avoid protections, and they'll go pretty far if you act badly enough. Sabrina Barber encumbered herself with, it was $60 or $70 million in debt in the prior to the real estate crash, you know, the 7, 8, 9 period. after she realized that she was in trouble, I think she had actually defaulted on the Wells Fargo loan, or she had a number of different series of loans in a facility. She started moving things around, okay, which is kind of the last thing you want to do. You want to see a competent lawyer. You want to calmly create a roadmap if you have options in terms of a strategy to deal with something of this size. So she didn't do that. She started moving things around. She used a Delaware bank account, which Delaware has some protections on bank accounts. She used a Nevis LLC. I wrote the fraudulent transfer section of this Nevis LLC. She used some great protections, but those protections are really meant for creating a structure on a sunny day in anticipation of potential problems later. They're not meant to just start funding things when you're running away from Wells Fargo. So what happened? Well, what I would have done as a judge, most likely, based upon what I know about the case, is I would have said, well, you've created fraudulent transfers. She was using entities all over, all over the country and offshore, but she left all her, the bulk of her assets in a Florida securities account, and she sold off her homestead, which was totally crazy. She probably could have kept the homestead, believe it or not. Leaving the accounts where the claim is also, I wouldn't recommend this kind of activity in any case, but what really tempt is the judge is not going to leave those security accounts alone if you're defaulting on $64 million and just kind of redistributing all your assets to what otherwise would be protective entities. So the judge said, well, I was going to tell you what I would do. So what I would do, I would say it's a fraudulent transfer. Let's pull back assets into an unprotected state where Wells Fargo could attach them, and that's kind of the end of the case. I think it's a fraudulent transfer case from what I'm saying. That's not what happened. So what happened was, this made my litigation partner, very happy because they argue for this stuff all the time. So what happened was the judge says, no, I know it says it's a Nevis. Nevis is an island that protects the LLC, where we created this very protective statute. I know it's a Nevis LLC, but we're going to call it a Florida LLC. And as a Florida LLC, it's a single member LLC, and it's not protected, and you're out. End of case. And that's what they did. So they called it a Florida LLC. They swooped in and took her securities account and all the money that was in the homestead that would have been protected. And that was kind of the end of the ruling. So you have to be very careful with this stuff. If you already have problems, you're not doing asset protection planning. You're reacting to the problems, which is very ineffective. There are some things you can do, but the idea is to do the planning on a sunny day. Now, as a contrary case, we've got this J.P. Morgan case. It wasn't really, from what I understand, it wasn't really a fraudulent transfer case. You have to realize some of these opinions are shorter than others, don't give you as much background. But they had litigation in, I think it was Arizona. The McClure lost, but McClure had Colorado LLCs with assets. So JP Morgan goes back to Colorado, which was probably a strategic error from what I understand, and says, okay, we're gonna now try to take these LLCs, I think some of which were single member. And when you enter the state of the LLC, you're now in front of a court that's going to usually pretty strictly interpret their state statute. And that's what happened. So even though the plaintiff had a judgment, and you can register your judgment in any from any state in any other state, that's why offshore work is sometimes very valuable, because it's much harder to register your state judgment in these foreign jurisdictions, but not from state to state. So they register the judgment from Arizona to Colorado. They say, okay, we want your Colorado LLC, but the court says, no, the statute And it's not that explicit a statute, but it's pretty good statute. Says no, it's protected. You can get the charging lien. And that was it. They could not collect, because at that point what happens practically is the defendant says, I'm not going to make a distribution. You're out of luck. And JP Morgan says, what does that mean? And the lawyer says, settle. So they settle for pennies on the dollar. I don't know what happened in JP Morgan, but that's what happens time after time with this stuff. When we have clients, we have not yet had an asset protection plan in 29 years breached. So what generally happens is everyone's at the table, you're now in collection, and you slide over the structure to these litigation people who are excellent at winning the case. What they don't understand are the protections. So what happens is they get the structure in the meeting, and they're like, well, we're going to have to hire an expert. We have no idea how to break through these structures. And the client's frustrated. The client's got the judgment. The client's paid a fortune in legal fees. And I mean, practically you settle unless it's just a very large judgment. Let's go to the next slide. Arroyos, to get you up to date, is the other side, even stronger for the defendant, where in the Arroyos case, the plaintiff sued in the state of Maine. I believe it was a Delaware entity, got the judgment, and then there was assets in Alabama, registered in Alabama, goes to court, I want the LLC. The Alabama court, so the Alabama court's got options. I know we have a few lawyers on the call, and we have some CPAs, but the Alabama court could say, we're gonna do a barber, we're gonna apply Alabama law. I'm not sure really anyone else is gonna do that. That was so wild, or we're gonna go ahead, it's a Delaware LLC, we're gonna follow the internal affairs doctrine, we're gonna follow Delaware. This was a Maine action, M-A-I-N-E. We're gonna follow Maine law. That typically sums up what courts will typically do at that point for choice of law. Now, Alabama court says it's a Delaware LLC. Well, I don't know anything about Delaware LLCs. You're gonna have to go back to Delaware. So the court essentially said that the court has no authority to rule on an LLC organized in another state. That's very powerful. That's the law. That's not an appellate decision. No, it's not an appellate decision, but that's kind of the law in Alabama. So you want to use your Delaware LLC in Alabama, that's for sure. And then this one goes through kind of an analysis of which interpretation is going to work. Don't run away, don't use another country unless you typically are going to put assets in that country or you have a manager in that country. What the answer is, we don't really know. The answer is to do it beforehand. Typically, if you're planning this stuff and you integrate an estate plan, years later you have a problem, it's almost always enforced in my experience. So this is now we get into the single member LLC. I want to make sure I'm keeping time here. We've got about 20 minutes. The single member LLC issue came about in the same exact way. We moved from corporate to this triple LP to the LLC. And what started to happen was you had people who would start their own LLC, single member, and they become subject to a judgment individually. Plaintiff would sue and they say, look, I got an LLC. The statute says that you can only get a charging order and I'm not making a distribution. And it would frustrate the courts because the courts for the prior 150 years said you just take the corporate stock. But that wasn't true with an LLC. And then to add insult to that, if you went bankrupt, the bankruptcy court typically turns to the protections afforded by the state. So actually Albright goes bankrupt. This was a movie star in, I think it was early 2000s. Goes bankrupt and says, well, no, I've got assets, but they're in a single member LLC. Court says, we just, in bankruptcy, you're going in, you're discharging your indebtedness, so your ability to argue to keep your assets is much more difficult. So she says, no, it's single member LLC. You can't take that. Look at the statute. The court says, we're going to find a way to get it. Because that's exactly what happens in these onerous or bankruptcy cases. And the court says, the idea of the charging order, I love that, is that if someone sues a partner, the other partner is unaffected. So you can lien the partner debtor, but you can't like take away their equity. Now the other partner's got a new partner. It disrupts the whole business. We're not doing it. So that was the idea. It's an English idea. That's where the charging order comes from. Totally, in many ways, unrelated to. It's almost a historical note only to the LLC statutes, but that was it. In bankruptcy, you don't want to be a single member LLC. Albright, and then 3 or 4 cases after, it says you're going to lose your equity if you're a single member LLC in bankruptcy. A really interesting case, which gives a lot of insight as to what the courts are going to do, is Olmsted, which was not a bankruptcy case, where it was total confusion. In this one, it wasn't bankruptcy, but it was a criminal who had duped a lot of people out of cash, lost the judgment, and it was against the FTC, which has unlimited funds to litigate the stuff. So they get the judgment, and Olmsted says, I got all my stuff in LLCs, you can't have it, you got to look to local law. Total confusion. So they certify the question to the Florida Supreme Court, which in many ways you couldn't make heads or tails, in my opinion, of the opinion. The dissent was exceptional, but the opinion was everywhere. The court goes so far to basically says that the LLC is just like a corporation. It's just a corporation, not the single member, not the multi-member. It's just like a corporation. So what happened was the legislature had to step in and say, no, hold on. It's an LLC. We're going to protect the LLC, but they gave in to the single member, and now the single member LLC in Florida is pretty much unprotected. So you have to choose a jurisdiction that says when the member is sued, the only thing you can get, the exclusive remedy, is the charging lien, and that applies to a single member LLC. It'll say it in the statute. Nevada has it, Delaware has it. We were using Wyoming years ago until Wyoming had a negative case where a judge kind of let a liability spin out of a subsidiary into the parent and expose the whole company. So no one really uses Wyoming anymore. But Nevada, Alaska's, Delaware, South Dakota is very good. You really have to choose your entity. Here's the background from Olmsted and Albright. You're pretty much done on the single member LLC. In any case, a lot of times, just to create a second member is just a good idea. It's just a good idea because these cases are out there. If we can create a trust for a child, we can do all kinds of business partnership issues, whatever. One may be more protected than another, but you don't want to be a single member. In that regard, we have one case that's somewhat enlightened, that creates some enlightenment into how the courts are going to react with this single member issue, even in a planning scenario. And it's California. California will have some bizarre opinions, but also sometimes is a window to what courts will do on future cases. So we have Corchi v. Baldwin, which involved a very wealthy developer, Baldwin, who had created a family entity a holding company and a number of LLC subsidiaries. There were trusts involved as well, and it was Delaware based. What happened though, a key error with this stuff is Baldwin was something like 99 and the spouse 1%. Well, it's very tempting to courts when we start this, what they call a peppercorn, little peppercorn to somebody else, to just ignore that. This case was a little more complicated than that. Basically, the standard was there was a lot of cases on corporations and how corporate entity could just be taken. They're totally exposed. Everyone kind of knows that. And then someone added that to a complaint that the corporate stock could be foreclosed. And the resulting litigation and cases were like, no, it's not a foreclosure. You can just take it. I'm simplifying, but that was kind of the line of cases. And then Corchi comes in, creates this huge corporate structure for the family with, I think it was like a few $100 million, and then kind of decides not to pay a debtor, like a really bad faith kind of thing. The debtor sues, gets the charging liens, and Baldwin says, even though I've made like $80 million in distributions over the last 4 or 5 years, 6 years actually, it's right here. I'm not going to give you any distribution. I'm not going to make a distribution. You're out. You're out. As an LLC, you can't get to anything. So he was kind of a bad actor in that regard. And the court said, basically the trial court said, look, we've got this law that says you can't break in, you can't foreclose out equity. And the appeals court said, no, that's for a corporation because you can just take corporate stock. And they allowed the plaintiff, Corchi, to make an action. They sent it back down to the trial court. They said, you can do it. You can sue and you can foreclose out that equity. So we have a case where if you don't have really a serious distribution of the allocation of the ownership, you may be exposed, especially if you're a bad actor. And here are some of the reasons. It's not really, when you're 99-1, it's really like you don't have a partner, which goes back to that Albright case. There's no other partner to protect, and it's kind of like a corporation in that sense, in that you can go ahead and foreclose the equity out. Now we note here on the slide, it was a Delaware entity again, and we get back into this choice of law issue. Why wasn't Delaware law followed? Delaware law says you can't foreclose because the internal affairs doctrine is often completely disregarded. That's kind of the state of the single member LLC law. A lot of courts, as this Glick case, have said, you know what, if you have a case and it's against a single member LLC or a multi-member LLC, our statute is clear and you cannot foreclose it. So we'll see the way the whole thing plays out. I think it's going to be somewhat negative. I think basically what's going to happen is you're going to have that second member. Offshore, we've taken some of the weaknesses in the LLC statute and we've kind of ameliorated them. For instance, the charging lien doesn't last forever, it expires. If the LLC is funded and someone wants to later claim, no, that was a fraudulent transfer, you've got to really do it within a year, right? And then there's some obstacles, like you have to post a bond and hire local counsel, etc. This is this NEVA statute. But remember, that's only going to apply in a planning situation. Otherwise, you're going to be treated like Sabrina Barber, and they're going to ignore the offshore statute and pretty much just apply the Florida statute. And if you're a single member LLC, you're out. So we use a lot of offshore structures. We use a lot of offshore trusts. Most of the time, you want to use a foreign trustee, almost always institutional. You can have co-trustees, you can have protectors, and a lot of times you'll use a foreign manager actually for a foreign LLC. This is some of the wrap up with Wells Fargo. This is that Sabrina Barber case where they ignored Nevis law and went back to Florida. Interestingly, a case around the same time, just before it, was called Sargent v. Alsala, where appeals court in Florida actually said, you know what, the LLC was certificated, so it becomes tangible. And the tangible certificate was held in the Emirates and in Dominican Republic. So we're going to allow your judgment in Florida, but you've got to go to Dominican Republic and the Emirates to enforce it. Much, much more difficult proposition than saying, like in the Sabrina Barber case, the accounts are in Florida, we're taking the accounts. Now, Sargent has to go with the judgment offshore to try to enforce and collect on assets offshore. Much more difficult. That case actually went on forever. I think it's still going on. And again, these are some of the lessons we've learned. Keep a portion of the assets offshore. Managers and trustees should be offshore. Here's some of the keys to the success in terms of the statute you choose. You want an exclusive remedy on the charging order, no foreclosure rights. No one can come in and dissolve the entity, which is was a strategy for a while. Operating agreement, you make your own rules, and no transfers. A funny in a way case was where this Crystal River got into it with BB&T, and they got into the collection side, and the Crystal River group says, no, we own husband and wife, and they're in front of a federal magistrate, and the magistrate starts going online. Of course, the online filing in the state is not determinative of ownership, really not even of management. So the magistrate says, no, you've got some of your entities, you don't have your wife on, so those aren't tenancy by the entirety. You're out. We're going to allow that. We're going to allow you to collect on those. And then they had to go back to the court and show in the operating agreements that there was a tenancy by the entirety ownership, and they were able to retain those LLC interests. But you just have to be careful with some of these details, and keep in mind that very few people really understand this stuff, including this magistrate. We've got 10 minutes or so for trusts. Trusts are what I had mentioned at the beginning of the program. You are basically, you put money in trust. There's a trustee who watches, manages, holds the assets legally for a beneficiary. On a discretionary trust, the trustee can move assets out to the beneficiary at their discretion. If you have moments or ages where the beneficiary receives assets, those assets are exposed. Now we have in 18 states the self-settled asset protection trust. Self-settled means that unlike the English law, which developed over 500 years, you can create your own trust. So if, for instance, you have an LLC and you can't find another member, you don't want a single member LLC, maybe we create our own trust in one of these states. We like Nevada, South Dakota. And that trust will protect the equity in the LLC. You create the trust. The trustee generally has to be in the state of creation. And the trustee will govern distributions technically. You can replace the trustee. And in most cases, you can continue to manage the assets. You just can't technically make decisions on distributions. And it does create quite a bit of protection as opposed to holding a single member LLC, for instance. We have defended several of these self-settled asset protection trusts, mostly in Nevada. Florida, for instance, does not offer it. We've got a couple of cases in the last 10 minutes. On these self-settled trusts, again, this was a bankruptcy case, Uber. We want to make sure that we can create the connection to the foreign jurisdiction. When I say foreign, I mean if we live in like Uber did in Washington State, we want to create a connection to Alaska. He created an Alaska self-settled asset protection trust, where he really didn't, in this case, create the connection. So with bankruptcy, again, you're going into bankruptcy, they're discharging your indebtedness. So your ability to argue, I get to keep everything, is very weak. They got into a public policy argument. I don't know how you argue against public policy, which is one of the reasons you shouldn't go bankrupt. And basically, one of the trustees was in Alaska. The protector was in Washington State. All the assets were in Washington State. The beneficiaries are in Washington State. They said this is essentially a Washington State situation. Guess what? Washington State doesn't have a self-settled asset protection trust. For public policy reasons, you're out. We're going to apply Washington law. You're going to lose all the assets. You have to create a connection to the jurisdiction of the trust. Mortensen is the mountain man who, this is the do-it-yourself, the DIY for asset self-settled asset protection trusts case. Mortensen did his own trust, actually didn't really do a terrible job in a way, created in Alaska. Now he's in Alaska, so he's got the connection to the trust, got an Alaska trustee, and so the assets go in. In Alaska, you have 4 years at that point. So this was a divorce issue. 4 years after, let's say, I don't know exactly what happened, but like after his wife knew he funded the trust, like I'm not sure how she would know in many cases, like exactly what the trust does. But after she knew, 4 years later, she can't get into the trust. That's what the statute says. And that's kind of the key to a lot of these, is the notice. So this was I think 6 years later, gets a divorce, says, no, everything's in trust. And they're into the litigation, and he files bankruptcy. Bankruptcy opens the statute of limitations up to 10 years. He had an open fraudulent transfer claim. She was inside the statute of limitations. He lost all the assets. It's an unbelievable case. This is Bertrand case. There's a lot of little technical requirements for some of these self-settled asset protection trusts. This is Alaska. There's a financial affidavit. You have to file them. You have to file all these little technical requirements, or when the trust becomes tested in litigation, you could lose. They could break through the trust. In this Trusco case, you had Florida litigation. I believe it was construction litigation, and they defaulted on the indebtedness to Trusco Bank. The debt was clear. The default was clear. What happened was they had the Florida litigation. They had the collection in Delaware to get the assets in the Delaware LLC. And Delaware, again, like that Colorado case, is going to interpret its statute strictly. The court actually avoided the issue by saying, Matthews told Trusco that it created this structure. You were on notice. 4 years passed. 4 years pass after notice. Trusco has no fraudulent transfer claim. And then Matthews kept the assets. Kirby Stillman basically is a case where you had a pool contractor do asset protection work in Nevada, funding the self-settled asset protection trust. Years later, there was a problem with the construction. I think there was like all kinds of problems with the development, and one was the pools. So he got sued, but he was very cavalier about the case, and he entered a settlement, and then he breached the settlement, and the court cracked the Nevada asset protection case even after the fraudulent transfer statute of limitations had run. It's a unique case. Do I think that everyone's gonna get breached after 4 years? No, I don't. There was an abuse of the system, and that's what happens when you abuse these courts, especially in a large litigation. We also can do foreign. It's the same idea. You create your own trust. You use a foreign professional trustee. A lot of times people are uncomfortable with that. Totally understood. We've never had a problem with it, but you can create a protector. So you can put your cousin or your brother or your sister in as protector, which means that even on the foreign trust, nothing can come out of the bank accounts held by the foreign trust until the protector signs off. Very protective, especially if we use an offshore asset, like an offshore bank account or securities account. Very hard to reach for one reason, really. The Florida or federal or U.S. court doesn't have jurisdiction over the trust. There's some onerous cases where the court tries to assert jurisdiction over the person, where someone's a bad actor, but in reality, they cannot reach the trust, especially in a foreign trustee in a foreign bank account. We note the Full Faith and Credit Act clause of the U.S. Constitution allows a judgment in a state, in one of the 50 states, to be freely filed in any other state and enforceable in that other state, state to state. Don't get that. They don't get the enforcement and filing ease offshore, and it's a huge factor. This goes through some of the ways to reach assets in an asset protection trust. You can be onerous, like Sabrina Barber. You don't issue certificates in these LLCs. Some people just go off the rails. You go bankrupt and they get to you for public policy reasons. It's technical, but it really comes down to plan on a clear day. If you do, very little likelihood that your assets will be reached. Here's a chart. We can obviously get you a copy of the program with some of the, this is an older chart, but it has some of the facets and advantages of some of the different offshore jurisdictions. The asset protection trust is very same, for the same reasons as that you can breach an LLC, are respect the entity, run everything through the trustee. It's not an open pot, open money pot. Follow the rules in the trust, follow the rules in the LLC. It's not a personal piggy bank. That's one of the major issues that cause the exposure of these structures. And to wrap up, I think we're about there. The keys to the effectiveness. Let's create a link between the entity and the people involved and the assets involved. Let's create substantive nexus of these things to the trust or to the LLC. Avoid the ability to use it as a personal piggy bank. With an LLC, it depends on the situation. Obviously, a business is a business. If we're using this as an investment vehicle or family investment business, we may want to put a trust on top of it. Avoid bankruptcy. Bankruptcy is great if we want to discharge assets, not great if we want to protect the other assets. I'm sorry, discharge liabilities. So great to get rid of debt, not great if you want to hold on to what you have. And don't be egregious. Create the structure for protective reasons, and you also may want to integrate other reasons such as estate planning. And that's it. You can reach me at the information here below. I'm available for questions. We can also send you a copy of one of my books or both books. We have a new textbook coming out. Some people like to read through cases, so we created a textbook. We may teach a few classes on asset protection and international tax law. And that will conclude our presentation.